Vignette 2. Power of Attorney and Accounting.
Emily and Saul, we're having another brief open session, okay? I wouldn't normally do this, but for entertainment purposes, I'm going to, all right? So the next issue that I want us to try to get some resolution on is this idea of you, Emily. You were the power of attorney for your mom, right? Or you still are. And I know that, Saul, you have some concerns about some of the money that was spent on your mom, right? Specifically, I think you raised the issue that in the last couple of years, there's been larger amounts spent, right?
Well, that's right, Jordy. Like as I said before, I spoke to my parents on the phone, and they were at my daughter's bar mitzvah, and it was clear that they couldn't remember who people were. They used to give gifts of $100, not $100,000, like when they tried to give the gift to my daughter. It was clear that they didn't understand their property. And my concern is that at their most vulnerable state, my sister pounced in, and her first $1 million that she took was essentially right after they were diagnosed with dementia.
But Saul, hang on a sec, because what I want to try to focus on, I know it's hard because we have a lot of things, but let's just try to focus on your concern about how Emily was dealing with your mom's affairs as the power of attorney, the spending in the last couple of years, I think.
Where I was going with that, Jordy, was that my mom didn't know what was going on. So I'm really concerned because I would expect that my sister would have receipts.
Right, okay. So
invoices or bills or something that would show what she was spending the money on.
Right, I hear you. Okay. So Emily, you can see where Saul's coming from, right? He's, this is your mom's money, right? So, right, it's your mom's money.
Saul, have you ever tried to hire a caregiver? Have you gone to any of the agencies?
Well, not one that would be like you and take all their money.
Well, have you gone to any? It took me months to find good caregivers, and I found these lovely, lovely ladies. They're so nice. They're so sweet. They only take cash. What am I going to do? I have to pay them cash. That's all I can do. And I saved you money. I saved you money because if I would have got someone from the agency, it was $40 an hour, and I paid them cash, and I gave them $20 an hour. So I saved you money. You should thank me.
Was that in between conversations with the pit boss at Casino Niagara? Because I have pictures right here.
Jordy, I think I'm going to leave, Jordy.
I have a picture of you right across the street from Casino Niagara from a private investigator, and it shows that you're taking money out. And the transactions that you have accounted for are like $500 transactions almost daily from that bank across the street from Casino Rama. So how is that going to...
Too bad you wouldn't spend as much time following me around. You could have used some of that time to take care of our parents. Maybe you should use some of that time and some of that money to come and visit our parents. You say you called.
I love Mom and Dad.
No, you don't. No, you don't.
I love Mom and Dad enough that I didn't take their money.
You didn't come. Where were you? You called once in a while. You called. No, that doesn't solve anything.
Called?
I think
you just called.
They didn't even know your name by the end of it.
Okay, I think this is
going
really well.
Where are the receipts?
It's going really well. I see we're getting a lot of...
I see you have new earrings and they're gold.
Well, that's good. Yeah, no, I think they're platinum. Here's the thing. Why don't we break up here and we'll go into our separate rooms for a second, okay? I'm going to just talk to Emily for a second, okay, Saul? You just relax. Wow, that was...
Is there good soundproofing here?
Yes, no one can hear us.
Thanks.
It's just you and me. So, Emily, here's the thing. Now, I'm not your lawyer or anything like that. I'm not giving legal advice, but there is some concern that when you were the power of attorney for your mom, that you spent money on her, and I know there was money paid to charity, right? Tell me a little bit about that.
Well, my parents always wanted to help people. They always had some cash, and they were always giving money to people, sometimes at shul or sometimes at different events, and I just wanted to do what I knew they wanted to do. So sometimes I gave some money here and there to some people who were visiting from Israel and some different people at the shul, and I said, this is from my parents, yeah.
Right. And how much approximately, I don't mean like to the dollar, but approximately how much would you have given?
$50 here, $50 there. I can't keep track, I'm busy.
Right. Well, I hear you, yeah. Okay, so you're busy. I understand that. Tell me more then about this the caregivers. So how many caregivers did your mom have?
So we started with one shift a day, 8 hours. They
Right.
came in the evening, let's say about 4 o'clock, and helped with dinner and help get my mother into bed and this and that. And then we had to go to 2 shifts. So 2 shifts, 7 days a week. And on a statutory holiday, you have to pay extra.
Right.
And on the weekend, sometimes you have to pay extra. And these were such nice people. They're so nice. And, I might have given them a little bit of extra money. They're so nice. But I saved my brother a lot of money. And how was I going to keep a receipt? They won't give me a receipt. They'll be deported if they give me a receipt.
So one of the things in law is we try to get some documentation or evidence of things. So I know you don't have receipts, but do you think they would maybe sign an affidavit, a statement saying, yes, they received the money and they were looking after your mom?
Well, one's no longer in Canada, so I don't have her address. I don't know where she is, and I don't know. You know what? I don't know. I don't want to get these ladies in trouble. If not for them, my parents wouldn't have had such a good life. So I don't want to call them.
Just so I know, because Saul's going to ask about this, did you ever think to get a lawyer when you got appointed and started acting as your mom's power of attorney? Did you ever get a lawyer to give you some advice on that?
You know what? I never got a lawyer. I didn't know that I was supposed to get a lawyer. I didn't really understand what a power of attorney meant. I didn't even hear the word vouchers until in his mediation brief. I was just doing my job. I didn't know I had to keep records. Nobody told me that.
Right. Okay. Thanks. I'm just going to talk to Saul for a second, okay? Thanks, Emily. Hey, Saul.
Hey, Jordy.
So I was just talking to Emily. I know one of your concerns is this idea of, where did all this money go, right? And vouchers, and you use that term. What do you think about her explanation that she's paid this to caregivers? Did you witness your mom having caregivers or any of that stuff?
Oh, there was caregivers. Yeah, and that's the whole point. My sister tries to come to the mediation and say, I did this, I did this. The only thing she did is get in her brand new car, which I can only assume she bought with the $2 million she got from Mom and Dad, that she took illegally, drove down to Casino Rama, and spent the whole day there. And because the caregivers, as I understand from her brief, were there 24 hours. So she wasn't providing any care. But she took the $2 million, and then in the last year, for which she did provide accounting, there's $156,000 or $150,000 that she has no vouchers for. I understand that if there's a cost and there is a receipt, and then you can kind of look at it and say, okay, Mom and Dad needed food, they needed clothing, they needed some care. Right. I get the reasonable aspect of the expenses. Right. But she's taken $150,000 in my view because there are no receipts for that. I know Mom and Dad didn't spend $320,000 in expenses last year.
But here's the thing, okay? So just listen to me for a second and see if you are familiar with the fact that many times people hire caregivers who aren't on the books, right? They're paid in cash. That's not uncommon, right?
But the 150 I'm talking about takes into consideration that, and it's the things that she can't provide receipts for. Right. If she doesn't have receipts, she got to pay it back.
But here's the thing, because if she has a reasonable explanation for that, even without receipts, there may be some argument. A judge realizes sometimes that these people who, kids who are looking after their parents as a power of attorney might not keep the best records. So it's more a question, I think, of reasonableness. I mean, if you saw that your mom's care, and you admitted that your mom's care increased, your dad's care increased over the last couple of years.
They were vulnerable, and she took advantage of that.
Right, but they also needed more care, right? Don't you think?
And she wasn't providing any of it.
Right, but she's saying she was spending some of that money on that.
Right, but she doesn't have receipts for $150,000. Right. And if you go talk to Bruno, the pit boss at Casino Niagara, he's going to tell you that she used to give $50, $25 tips when she'd win a hand at the blackjack table.
And have you interviewed him?
I've got a private investigator's report with pictures of her across the street from
I'll have a look at that
Niagara.
For a second. Yeah, because I mean, all of this is helpful because she has to understand, and I don't disagree with you.
Well, and if you look at her transaction that she did provide,
right,
it shows withdrawal cash. Right. Right across the street from Casino Rama from that branch. Right. So how does she explain $500 daily across the street from Casino Niagara, an hour and a half away, when the caregivers are here in Toronto looking after Mom and Dad?
Right. So okay. So we're getting somewhere. We're at least we're isolating some of your concerns. So that's good. I think, guys, what we should do is probably turn this over to some experts to get their feedback on this whole issue of accounting as the attorney for property, and what about this pretty routine situation where there aren't vouchers for every single dollar spent. There are allegations of cash payments to caregivers, not unusual necessarily, and so how to deal with this pretty familiar fact scenario. So I'm going to introduce the chair of our next panel, and that's Kimberly Whaley, who is the founder and principal of Well Partners, exclusively practicing in estate and capacity litigation. And Kim is also a mediator and a distinguished fellow of the Canadian Centre for Elder Law. So I'm going to turn the panel over to, or the microphone over to Kim, and she'll introduce the rest of her panel.
Good morning, everyone. So an accounting claim is becoming more and more commonplace, and it's often sought against a wayward attorney such as Emily to rectify an abuse, a misuse of a power of attorney, improper or imprudent spending of a person's assets. And in this case, Emily spent money from 2012, and she's a fiduciary, and she is accountable. Often family members will bring applications for leave, seeking the removal of an attorney and accounting, the appointment of a guardian, and claims against attorneys are also brought by the grantor of the power of attorney. And then, even after the person has died, accountings are sought against the former attorney and as against the estate trustee as well. We also see criminal proceedings, although that's not what our panel is going to concentrate on today. Criminal proceedings often involve accountings under the criminal code for theft, criminal breach of trust, forgery, extortion, fraud, failure to provide the necessaries of life, theft by a person holding a power of attorney, and criminal negligence. And a couple of years ago, Section 718 was added to the criminal code, which provides the courts with additional factors to increase the severity of sentencing where victims are older or vulnerable. So our panelists will now speak to some of the court process, the evidence required, and litigation tools to assist in prosecuting these claims. It is my pleasure to introduce today the Honorable Susan Greer, who joined Amicus Chambers in 2014, where she now mediates and arbitrates these sorts of disputes. And this is after her 23-year career as a judge on the Ontario Superior Court of Justice, where for 11 years she was the lead judge for estates and also was on the case management team and concentrated on family law matters and on the divisional court later in her career. And this too, after an 18-year career as the head of the Estates and Trusts litigation group at McCarthy-Tétrault. Susan Greer also was honored by the Ontario Bar Association more recently and received the Award of Excellence in Estates and Trusts. Melanie Yach is a partner at Atin Berlis, and most of you here likely know Melanie. She not only litigates, but she also does administration and drafts wills. She is the editor of an annual publication with Canada Law Book on the Estates and Trusts here in review. Mel is often a frequent speaker at the Ontario Bar Association, the CBA, and the Law Society of Upper Canada. Susan Stamm has been counsel at the Ontario Children's Lawyer since 2007. She is in the Property Rights Department dealing with estates and trusts, both in litigation and administration issues on behalf of minors. Susan was also in private practice for many years, doing justice, litigating estate and trust disputes. So, given the vignette we just saw and the rather contentious dispute as between Saul and Emily, we thought we would start with a few questions. So we'll start with Melanie. In an accounting application where there is an absence of voucher material, like in the case of Emily, and backup material, and really an overall insufficiency of accounting evidence, what arguments could you use before a court asking the court to find perhaps an adverse inference against Emily in that she can't account properly?
Thanks, Kim. So in the binder that you all received today at tab 9, I have a short paper dealing with some of the 4 or 5 of the important cases dealing with adverse inference. The starting point, though, in this vignette is the recognition of the fact that Emily has an obligation under the Substitute Decisions Act, and in particular the regulation under the Act dealing with accounts, to maintain proper books and records and to be in a position to explain how she deals with her mother and father's property. So recognizing she has a statutory obligation to account for what she has done, it is a fairly simple matter, I think, if you're acting for Saul, to argue before the court that she has a positive obligation to explain each and every one of the transactions relating to her mother and father's property, and to argue that if she fails to provide an explanation, that an adverse inference ought to be drawn from her failure to explain, and that she should, and we'll get into this in a little bit more in a detail in a moment, I believe. The concept is that if she fails to account, she either has a reduction in her compensation to the extent she's claiming compensation, and if she's not claiming compensation and to the extent she depletes compensation, that she has to pay damages back to mother or father's estate in respect of the money she withdrew. In the case, or rather in the paper that I've provided you with, there are 4 or 5 cases that are directly on point here. And what you'll see as you look at the cases, Fareed versus Wood is, I believe, the starting case, 2005 decision, where a lawyer was acting as an attorney for property and failed to keep proper books and records. By the time he was called to account for his administration, there were no bank records available. And what's interesting in that case is that in deciding whether or not to draw an adverse inference, and in this case the court, in that particular case rather, the court did, the court looks at the reasonableness of the explanation that's provided by the attorney for property. So this is something that Jordy mentioned in the little vignette. An attorney for property is going to be given an opportunity to explain why it is they can't account. Their profession, so in the Fareed versus Wood case, it was a solicitor who had failed to account, and that was seen to be important. In this case, we have Emily, who is not, by her own admission, educated. She isn't out in the workforce. She didn't seek legal advice. Now, I want to stress there's another case that I've mentioned, Foley versus McIntyre, which stands for the proposition that ignorance of your duties is no defense to the argument that an adverse inference should be drawn. But, and I'll just wrap it up at this point by saying a judge is going to look at all of the surrounding circumstances and the explanation that Emily provides to decide whether or not an adverse inference ought to be drawn.
Thank you, Melanie. Susan, tell me, what tips could you share with the lawyers who are prosecuting these types of claims on either side?
I was thinking about that, Kim, and I remembered something the late Rodney Hull used to say about executors and compensation and so forth. And I put it, he used to talk about, you think about it when you go to bed, you think about it when you first get up in the morning. And I put it into the perspective of accounting. I spent, as you heard, all those years on the bench, and I did many, many, many cases of contested passing of accounts. The lawyers and the person who had the power of attorney never thought about vouchers. So I say to you, think about vouchers in your role as a lawyer, and think about vouchers in your role as an attorney. There is, I think, a very important point about getting forensic accountants involved. If there are millions of dollars involved in the estate, by all means, get a forensic accounting, because that is one of the only ways that you are going to be able to persuade the court that the money wasn't really stolen. They never like to hear people say, well, the money was stolen, because there are no criminal charges. So the money is missing. And where did it go? Emily's excuse about giving it away to the poor doesn't ring very well. Is it plausible, is really what Melanie was saying. Is the evidence plausible? No. But is Emily dishonest? Likely not. After all, she was looking after her parents. So her lack of vouchers can be traced often with court orders to produce bank accounts, court orders to freeze her assets until the accounting is completed or the court trial is completed. Eventually, there will be a notice of objection to the accounts, and that has to be done with very great particularity. So it's not enough to put cash. Cash? Where did cash go? Well, we know it came out of the bank if you had the banking records. So those are the things I think that you've got to really remember. And the description in the accounts is very important. And of course we know that the brother knows she went to the casino. So is there an adverse inference that she actually did spend more than the amount that even he is able to trace? So think about those tips when you're looking at the accounts from either side.
Thank you, Susan. Sue, given that there is a minor beneficiary with an interest of $150,000 in the estate of Mel, and there is a contentious accounting procedure going on, what typically would we expect from the children's lawyer in terms of a legal position in the proceedings?
So the children's lawyer is one of two provincial appointees that get involved in private estate litigation. The other one is the public guardian and trustee, and Richard Coutinho is going to be speaking a little later about their role. They act on behalf of incapacitated adults, and the children's lawyer acts on behalf of minor children. We also have another role on behalf of the unborn, so a trust that has not yet been determined will likely have an unborn interest, and our office serves a public function in helping that interest be bound into litigation. We don't have a typical position. We are a litigant like any other. So we are served in this case to act on behalf of a child who in some manner has been denied $150,000 from Mel's estate. So that's our primary interest at the moment. All of the interests concerning the ongoing administration of Selma's estate while she is alive, we would think would be more of the public guardian and trustee's role, and we would take a very big back step in that. We may stay involved, but we would certainly not take the lead. So what you would usually expect from us if we're acting for a legatee, so someone who's getting the money up front and right now, is we would try and get the parties to take us out of the litigation and find that $150,000 and pay it into court where it's safe for this child. So, for example, we would be trying to encourage Emily to sell her Florida condo. Hopefully it's worth more than $75,000 US, and with the exchange rate, we might be almost there, and try and get that child paid out, and our office would then essentially not be involved, not add a whole layer of cost onto the litigation, because yes, we do expect to receive costs from the efforts we put forward in litigation, just like other lawyers do. So that would be our initial push when that didn't occur because, for example, Emily has mortgaged the cottage in Florida to its hilt or beyond. We would stay involved and we would follow the litigation. We would typically let Saul take the lead because we are unlike other litigants. We don't know about Emily's gambling issues, and we can't lead that kind of evidence because we don't know Emily, but he does. And so we would take a back seat to Saul and provide, I guess, a moral push-up. We act for the child. We're on the side of the angels. The courts, in some way, look at us slightly differently than other litigants, even though we are entirely partial on behalf of the interests we protect. There is a view that we have some level of balance and neutrality in our litigation. Whether that's entirely correct, I don't know, but there is that view, and litigants love to have us on their side, the children's lawyers on my side of this case. And so we would strategize with Saul's counsel in trying to find a cost-effective way to get this litigation resolved and this child paid.
Thank you, Sue. Melanie, we heard Susan speak about a tracing order and preservation orders. What is the extent of the professional and personal liability of Emily in her capacity as a fiduciary?
So Emily has a couple of roles or hats that she's wearing. She's acting, she acted for a period of time as her father's attorney for property. She was and continues to act as attorney for property for her mother. She also acts as the executor or estate trustee of her father's estate. So she has various roles, and she is a fiduciary in each of those three roles and has a duty to account, as we've talked about. And if and to the extent she can't account, Saul might seek, pending a resolution of the accounting issues, as Justice Greer indicated, Saul might seek an order, what we call a preservation order, that would prohibit her from depleting the estate, that would force her to pay her own legal fees as she defended these various claims by Saul. And as the accounting progressed, she would also be, presumably, at Saul's instance, ordered to trace or provide a tracing of all of the monies that she received. So, for example, in the earlier vignette, they talked about the $2 million in gifts that were paid over out of Mel and Zelma's property to Emily. She would have to provide an accounting of where those monies went. So bank statements, tracing where the monies came into her bank accounts to the extent GICs were purchased, copies of the GIC statements, and so forth. And over the course of the accounting, she would, I think, almost certainly have to provide very detailed financial disclosure confirming where the monies ultimately ended up. It may well have ended up, for example, in a rental property that she purchased, or it's sitting in an investment account. But either way, she's going to be presumably forced to explain where the money went.
Thank you. Susan, I'm thinking McMichael estate now, something that you know something about. What other protective orders ought to be considered by the lawyers prosecuting these claims on an interim basis?
I think the most protective order is like a Mareva injunction. It is an order freezing the assets, would be the assets of Emily. In this case, an order preventing her from acting on the power of attorney to take money out. So preserve mother's money, preserve estate's money, preserve Emily's money, if possible. These are difficult orders to make, and there has to be a very good case made. Those of you who've known me for a long time, I'm forever mentioning the Penna estate, but that was the perfect example where a Mareva order was made freezing the executor's personal assets. He had to give an accounting of his own assets, and there were millions and millions of dollars missing. That is the beginning, and of course there's orders to remove. So Saul might be wanting to remove Emily from all other things, powers of attorney, and as the executor of her father's estate. There are also, I might mention will say statements that are important to get from persons who are going to be called as witnesses. So might be able to get a will say statement from one of the caregivers, if you can get their names and find out who they are. Neighbors are very helpful in giving evidence of people's spending habits. That's how the income tax department, CRA, finds out. Their voluntary will say statements to there, but it is very important evidence about the lifestyle that Emily is leading. And it was interesting to hear Saul say that Emily would take days off to go to the casino, and the only people with mother and her father, I guess before, would be these caregivers. Their orders can be made seizing, and these are very difficult orders because they're like a Mareva, seizing the laptop computer of a person involved in this. Orders can be made ordering the bank to release bank statements, or mortgage applications are another one that are often used to find out what assets people actually say they have. So those are things you can think about as you're moving through a contested passing.
Thank you. Sue, tell me what would the Ontario Children's Lawyer's position be with respect to any unborn and contingent interests in the estate?
So assuming that the wills in this case provide that Saul and Emily will inherit an equal share of their parents' estate, of their mom's estate when she dies, but if they die first, which given the stress of all this litigation is certainly possible, their issue would inherit. And that would be a very typical way to draft a will so that the two branches of the family would ultimately be treated equally. In this case, Emily doesn't have any children, so all of the money, if she passed away, would end up on Saul's side of the ledger, because it would pass up through mom and then back down to the brother in our sort of bloodline analysis. And this would be this child that we act for, the one who's getting the $150,000, we hope, and out of both estates, and then also an unborn interest. For example, if Saul had more children, or if Emily adopted some children, all of which is possible, although not particularly likely, given the ages we're dealing with. So our contingency here on behalf of the unborn is not a hard contingency. It's a very soft contingency, but it still is a contingency, and that interest needs to be protected. In a case like this, when you're hearing about the kinds of efforts you're going to have to go to find out somewhat what Emily did with this money, and truly, we're probably never going to really know because she was dealing all in cash, probably somewhat of an unreliable witness. She's come to a belief in her story that may have some truth and some not truth. Usually there's a little bit of both. And the cost of unwinding all of this will be in the hundreds of thousands in legal fees and accounting fees and getting bank records and bank analyses done. And that, never mind all of the medical evidence that you have to pay for to put a case like this together, and a multi-day trial. And the end point is, what does Emily have left? What is she holding? Presumably, if she's got a gambling problem, she's not holding much. And it may be that the only way this case can reach resolution is with some kind of a different distribution of Selma's estate at the end of the day, and putting someone else in place to manage Selma's money in the interim. So that would be a way we would be looking, but our office would complicate that kind of resolution. Let's say 70% of the residue is now going to go to Saul and his issue, and some to Emily. But now Emily's unborn interest is somewhat being harmed by this settlement. And so our office would have to make sure that all these unborn rights, albeit contingent rights, have some protection in this settlement, and it complicates matters. But on the good side for everyone, that unborn interest is bound, is completely bound by the settlement. And that is something that is good for everybody in the litigation, because it may be that someone else is going to inherit that someone who is not born yet, and that person needs to be bound so they can't come back and say, hey, no one looked out for my rights in this litigation. So it is a complicating factor, and it's usually a great annoyance to counsel trying to settle these cases when our office says, wait, there's an unborn interest here. We have to figure this little piece out. It's usually not terribly expensive to figure it out, but it can result in some payment into court on behalf of this unborn interest.
Sue, I've never been annoyed by your office. I have a question, though. Would your office participate in that mediation, or would you wait and see what the outcome was? Or
if the $150,000 were not paid, we would participate. I'm pretty sure we would participate. That's a direct interest that was payable immediately. So yes, I think we would participate. I mean, it does also depend on how strong Saul's counsel is in bringing this forward, and whether we think Saul would be at any point likely to put his own interests ahead of his child in a settlement. But I think given that both Saul and the child are at play here, we should probably be there.
Okay. Melanie, now can you tell us a bit about why the rules dictate that the passing of accounts or the preparation of the accounts be in a particular format, and why it is, or how it works?
So there is, as many of you know, a couple of different principal formats of accounts, whether it's for an attorney for property, for an estate administration, or for a trust administration. And the form in the case of an attorney for property is set out in the regulation under the Substitute Decisions Act dealing with accounts. And it specifies exactly what needs to be set out in what we'll call the court passing form of accounts. The objective with the format is to ensure that each and every asset is accounted for, and that each and every disbursement is accounted for. So if you turn to the regulation, and I have summarized in my paper the various details of the regulation, but the concept is you start with the opening balance, and the opening balance is going to be as at the date, in this case, that Emily assumed responsibility as attorney for property for her mother and her father. She's going to have two sets of accounts, so one dealing with her father's property, one dealing with her mother's property. And as I said, she starts with an opening balance listing all of the assets that came into her possession in her capacity as attorney for property in the case of mom and of dad. And then in the court passing format, there are three separate ledgers or accounts. One tracks capital in and out, so capital receipt, capital disbursements. Another ledger tracks revenue receipts and revenue disbursements, and then as well there's a separate ledger tracking investments. So when capital is converted into an investment in the form of a stock or a bond or a GIC, it's tracked in a separate ledger. But the accounts, if you're familiar with them, run chronologically. So you start with the opening balance, and then you've got all of your capital in and out, revenue in and out, and investments in and out chronologically, and you end up with an ending balance at the end with your original assets, which you have yet to realize upon, and your investments and cash. And if you've done the accounting properly, everything should balance. And the key point in the regulation, I would suggest, is that each and every disbursement has to be explained. So as Justice Greer said, it's not enough to simply say cash. You have to be specific about what the disbursement relates to. So, you know, payment made to caregiver, you know, Jody, you know, and then you might put in cash. And some accountants, if they're putting the accounts together, or attorneys for property, if they're doing the accounts themselves, will provide cross-references to the specific bank account or the like that the monies came out of. But the end result ought to be accounts that are very, very detailed and that provide particulars of each receipt in, each disbursement out, each investment, and the like.
Thank you. Susan, where there is a resistance to fully or properly account, I know that you, when you were a judge on the Ontario Superior Court of Justice, were very progressive in the sorts of orders that you made to obtain an accounting. I wonder if you could talk to us a little bit about contempt orders in civil proceedings.
Yes, there are contempt orders can be made civilly or criminally, as Kim spoke about earlier. The certainly important ones for the people here in this room are the civil ones. And Rule 60.11 deals with civil contempt, and it's to enforce an order requiring a person to do an act other than the payment of money or to abstain from doing an act, and it's done on motion to a judge in the proceeding. So I did mention that Penna Estate that I did for over 7 years, I think it was, 6 maybe, that ended in a contempt motion. And so to do an act or not do an act can be a breach of a court order. And in Penna, there were 5 breaches of different court orders. Or sorry, there were breaches of 5 different court orders. And when you look at these orders, you look to see if it's an order made in the face of the court or an order made during the actual trial or motion or application. Those made in the face of the court, if you look at the cases, they use words like high-handed disrespect, deliberate and determined, contumacious, calculated, to deny the court order and its process by way of disobedience. That is within the actual court, and it can happen more often with self-represented litigants, and we do get those on the state's list, more so, of course, in family law. So they tend to get very exuberant sometimes, yell at the judge, and so forth. It's a hard call in cases like that, but in the evidence where orders have been breached, then the court has a hearing. And at the hearing, you look to see, is the contemnor going to apologize? Is there any rectification of the breaches? Is there any purging, we call it purging of the contempt, in order to eradicate the bad thing that has happened? And in that, the cases look at proportionality. Is it a small amount involved? They look at the aggravating circumstances. They look at mitigation factors. Mitigation would be paying the money back that inadvertently was taken. They always say it was inadvertently taken, or I just borrowed it and I'm planning on paying it back. And there are penalties involved. The judge in hearing a contempt, and I read a recent case, it's a civil case, came out of the court really at the end of the year, called SICO, S-I-C-O versus, cannot remember, it's a civil case, not an estates case, but there, the court, in looking at one of the witnesses in the trial, found the witness to be non-responsive, confused, and vague, and that witness was a lawyer involved who had given incorrect advice to her client, and then the client was being held in contempt of a court order. So time is up. The last point is going to jail on a contempt motion, quasi-criminal, in the Penn estate. The executor went to jail for 14 months, upheld by the Court of Appeal.
Thank you very much, Justice Greer and Melanie and Sue. On a final note, before we move to the next panel, I just want to say that I would never have gotten away with not doing a paper. Charles doesn't permit that. But this year, our firm produced a book, so please make sure you take your book on powers of attorney with you today, because I don't want to lug them back to the office, okay? Thanks.